expensive time taking in order to India. It is there long back in historical from Vedic period itself. But in India, when it comes in a real sense, what we are seeing now, I started with the Industrial Dispute Act 1947 for the first time, which has introduced the duty of mediating in and settle for the settlement of the labor issues. That was the first of its kind. Then later, Military Legal Service Authority Act has brought something more in order to help the people for accessing justice. This is one of the method they thought and started it. Formally, though it is an informal method, formally it has come to India in 2000. American people, American Institute of the Study and Development of the Legal Studies. Even
Sorry for the inconvenience. Sir signals కొంచెం తక్కువ ఉన్నట్టున్నాయి. He will come back. Yes, sir. Yes, sir. Yes, sir. I'm doing. Sorry,
okay,
sir.
no problem. I'm visible and audible here? Right.
Yes, sir, you're audible. Thank you.
Yeah.
Ma'am Sridev garu, you pin him so that his screen will go up. గ్యాలరీకి వెళ్ళండి, వ్యూలో గ్యాలరీలోకి వెళ్ళి స్పీకర్ తీసుకోండి ఆప్షన్, లేదా ఆయన పేరు పైన 3 బటన్స్ ఉంటాయి. ఆ 3 బటన్స్ క్లిక్ చేస్తే బ్రింగ్ హిమ్ టు స్టేజ్ అని పిన్ అని వస్తుంది. పిన్ కొట్టండి, పెద్దది అవుతుంది స్క్రీన్.
Yes, sir. I did the same. Actually, అది యూట్యూబ్ లో వస్తుంది. మన స్క్రీన్ మీద మనం ఆప్ చేసిన దాన్ని బట్టి మనకు వస్తుంది అనుకుంటా. స్పీకర్ వ్యూ లోనే ఉన్నారు.
గారు గో హెడ్.
Yes, thank you. So though we have the good number of alternative methods for litigation, just like arbitration, conciliation, negotiation, mediation, in modern world, after 2000 onwards, the importance of the mediation is increasing day by day. Many enactments and legislative bodies also thinking the importance of this particular mediation and inserting the concept of this mediation into a good number of enactments which are coming now and also which have been earlier also in the part of this. That shows the intention of the government to encourage the mediation and mediators, which is going to be a lucrative job for our young people. Young people, if they are trained well, they will be in a position to capture the new business which is coming in a different part of it. Okay. And now coming to the mediation, as I already told you, for the first time, the training is conducted in Ahmedabad in 2000 by American Institute of the Study and Development of the Legal System. Thereafter, a trust is constituted in 2002 in Ahmedabad. That is the Institute for Arbitration, Mediation, Legal Education and Development. The trust has taken a lead and conducted the programs in many centers, many cities of the country, and which has created a challenge to the government to come into the forefront and encourage the mediation part of it. As you know well, mediation is a part of dispute resolution, alternative dispute resolution, that's what I call it. They are negotiation, conciliation, and dispute. The three things are totally different from the arbitration. Arbitration is nothing but adjudication, whereas the three things are not adjudication, but facilitation part of it. Negotiation is the first stage, then mediation, then conciliation. The evolution of the dispute resolution methods, conflict, or the concept has grown just like that. Coming to the why we need in a modern world, when people are more knowledgeable, there is every possibility of coming with the differences, thought processes. When there is a lot of difference, then people may understand their perception. They will be having their own perception. With the change in perception, there will be disagreements. When there is disagreement, there will not be a consensus. When there is no consensus, problem will be coming up. Added to it the ego, added to is self-interest, added to is the available infrastructure. So three factors will make this particular issue as a very big converted into a dispute. So differences converted into disagreement, then problem, then coming to different disputes. As long as dispute prevail, no changes, no progress, nothing will be there. And crores of rupees are tied up in the disputes in the courts and also among the people. Now it is necessary in this modern world, every pie that is there among as an asset is to be used perfectly so that they can get the benefit. That's the purpose for which the people are running after the dispute resolutions. And ease of doing business is also having one index, one of the indexes saying that the country in which the dispute resolution is very faster, then the investments will go on. As a result, the ease of doing business will also increase. There's a purpose for which the mediation has become much more important. So when this difference has converted to conflict, it is a must for them in order to resolve, and that resolution will come through the mediation because it is a very easy method, independent method, and it is a method by which people can have their control. For that particular purpose, it's become a very important part of it. Next. When conflicts comes, it will be having three P's. One is people, second is process, then problems. What is the people? There is a people will be there with the total ethics and values. And there will be, Mr. X will be having his own history, experience. When he's having his own experience, he may be not taking any kind of proactive role in settling the issues. That's the biggest problem. And second is, every person will be having its own historical ethics and also values coming from the family members, coming from the generations, all those things. Then relationship is another way which will be coming on our way to settle, whether to settle or not. My father did it, so I want to do it. I have a relation with Mr. X with whom I have a problem. I cannot go extend much more. I cannot be very stringent because of my relations and emotions, behavior, personalities. I'm a central, I'm introvert. When I'm introvert, I cannot speak up. When I don't speak up, the issue will not be settled. That's why people with his own traits will be one of the biggest problem in order to settle the issue. Then second issue with the conflict settlement is process. I have a lot of feelings in me, I have a lot of emotions in order to that particular house which I want to sell or which I want to possess, which I don't want to live. So for that particular purpose, I had to communicate my feelings which are there in my heart to other people. When I communicate, other people may not understand what is my feeling. My feeling may be misunderstood. My feelings may be understood in a different way. As a result, the solution itself is a very far away for me. In order to achieve my goal of getting the conflict resolved will be running away from me because of lacking of communications of my own things part. Second thing is structure, systems, procedures. I know I can do it across the coffee table, but to what extent it can be enforceable, to what extent it can be recordable, to what extent it can be finalized, and the end results, what we expect will be there. That's a part of it. When there is a system already defined by the law, when there's a system which is already defined by the customs, I have to follow them. If I'm not to follow them, though we agree upon them, it will not be possible for the people to enforce them, even though both the parties to dispute may be ready to enforce. That's another important what is called problem in our doing this. Then decision making. Decision making always the biggest problem in the management. To do or not to do, to purchase or to share. All those decisions will be having a dilemma. That is dilemma in doing the things. Dilemma will be pulling you out. Whether I could go for the litigation, whether I have to go for a mediation or conciliation. So it will be making me making the people to think it twice and thrice. As a result, the process itself will be delayed. And related roles and jobs. I, as a personally a friend of you, I may be accepting the proposal given by you in the interest of our relationship. But if I am the manager, if I am the director, or if I am the CEO, I may not be able to dispose that particular thing as I thought or as you thought. So this will be coming in the way and hindering our own activities part of it. So people, process, and different kinds of problems will be also coming up. Problem means we may be misunderstanding about the facts of the case. We may be misinterpreting the facts one way, one my way, or information available to me may be different from information that you have. So the facts may be causing a lot of disturbance in our settlements. And the positions I'm a given, you are a taker. If I'm giving, I always think that my interest should be protected, and you, as a person receiving in the, you'll be interested in your what. When my interest and your interest conflict come together, there is a possibility of the conflict. So interest, that's another. And issues, religious issues, social issues, economic issues, agriculture, so many backdrops will be there in order.
So before proceeding further, sir, I request you to tell the difference between negotiation, conciliation, mediation, and
Yes, I'll come back. After
okay.
I'm talking of the conflict only, but after conflict we'll go there.
Okay. Thank you, sir. Thank you.
This is a conflict about the people process problem. Why conflicts are increasing? That's my idea. Okay. Perceptions also make the conflict more serious. Interests, needs, and lack of solutions. These are the problems will be coming in order to increase the conflict part of it. When you're going for the conflict, there are only three important parts, the important elements. Next, there is a requirement of support of the people in order to settle the problem. There should be effective process to deal with this. There should be alternative solutions for the problem. If you have the alternative solution to the problem, you can select 1, 2, 3, which is the best. If you have the process already defined, so that can be enforceable, then support the people. So these are three elements which are required for the solution part of it. Coming to the part, as I already told, there are four parts of our alternative dispute resolution. One is negotiation, second is mediation, third is conciliation, fourth is arbitration. All of us know what we mean by arbitration. People will be selecting their arbitrator, and they themselves will be, to them we'll be presenting our case. They themselves will be adjudicating. Maybe single arbitrator or three bench arbitrator, like the different kinds of the models are there, arbitrators. So we are having our own model when we go for the arbitration part. It's a kind of adjudication process totally, just like equivalent to litigation, but in a different way. Coming to the negotiation. Negotiation is discussing the issue across the table by the parties concerned. I'm having some problem with B. I'll go to B, sit with B. I'll tell my problem to him. B, if he's kind enough, he'll be hearing it. And we can discuss the problems, resolve something, how to do it. When people are full of emotions, this may not work. This may not work. When I go, instead of telling my problem, I may shout against that particular person. Other person may take that shouting and he further shouts. So there is every possibility of increase in the conflict because of the negotiation. But it's the best way and best easy way without anybody's involvement. If the parties are ready to resolve, they can sit together, discuss it together, and finalize together, and with the emotions controlled, with the solutions searching for them, then it is the negotiation the best way. And second is the mediation. Here, people will be negotiating X and Y. Both the people are in the conflict. They will sit together and start discussing in the presence of third party. Third party we call the mediator. Third party will not involve in the discussion part of it. Only he will be facilitating you. He will be only a catalyst. He will create an opportunity. He will create a platform. He will create an understanding of the issues, the importance of the mediation. Then he will be making. It is nothing but a third-party involvement or third-party facilitation to settle the dispute among the two people. People will be only two. They themselves will be discussing. There is a possibility that the dispute person may be assisted by its own counsel or the lawyer. One side, other counsel, and other problem, other person. So 2%, 3%, one side, 2%, 3% other side, supervised by the mediator, who is totally neutral, without any kind of interest or partiality, and that particular person will be giving a platform to you. Is only catalyst, you'll make it. This is a kind of a mediation. In conciliation, the mediator plays a different kind of role. He'll be talking to the party one and party two. Sometimes if they are coming to solutions, if there is a small difference between them, he'll may guide them, he'll may suggest them some solution out of these people, and he'll help them to arrive that particular part. He will conciliate, that particular mediator will be conciliate, so that the mediator will become the conciliator. So arbitration. Four things will be only a part, a alternative to litigation part. So conciliation, again, the party's suggestion may be taken. The mediator become the conciliator. Conciliator has to give some kind of suggestion. May or may not accept it. Whereas mediation is the best way, wherein entire process driven by the people themselves. People in the dispute, they themselves. Nobody will be in their own part of their behind it. So this is the advantage of the mediation. Mediation is better than any part. And out of the mediation is the best, because parties to the mediation will be maintaining confidentiality. They will not discuss, they need not discuss, they need not have a chat with the other people, group of people, whatever they discuss in the mediation room. The mediator himself will be maintaining confidentiality. As a result, the confidentiality is one of the most important element in the mediation part, whereas it may not be there in conciliation to some extent. Whereas the mediation is a private kind of a activity. It will be discussed among the people, two people, or one person this side and one person other side, under the guidance of the advocate. So nothing will be wrongly interpreted. So face-to-face negotiation in the presence of advocate or counsel and also the mediator, that's advantage. This mediation is totally cost-effective. It may sometimes settle within one sitting or two sittings. Just like an adjudication part, arbitration part, it need not be settled, sat for a long time. And there is no need to follow any kind of the formal evidence or procedural laws. It is informal way of doing this. There's no formal way. That's another important area. And lot of flexibility there in mediation compared to the conciliation, compared to your arbitration. So lot of flexibility. Time and place can be decided with the parties themselves. Or mediator may decide after discussing with the parties, let us sit on this day, irrespective of this holidays, place, evening, now morning, it's what of the timing. Lot of flexible there. And the entire process of discussion will be in the control of the parties themselves. No third party will be giving timings, beginning to the end. Only the mediator will be giving how it has to be done. Only he will be facilitating, give the opening remarks. Then what are the rules they have to follow, they will be giving. Other than that, mediator has no role to play. Whereas in other parties, more than that. That's why it is a totally in the control of the people. Entire mediation will be run by these people. And when the parties agree to sit and discuss about the mediation, the emotions will be lost. Realities will be coming on the screen. They can explain their problem to the other party in its own. Remove all the curtains. Nakedness will show this is the problem. Other party also understands what actually problem is. There is no requirement of any kind of decorations for that. This is my idea. This is the decision one. This is the outcome I am expecting. 1, 2, 3. They can say. Other party also agree or not agree. That can be said. And there is no. As a result, the relationship between the parties will be understood. If the third party enters into the system, there is a possibility of manipulations. As a result, relationship also breaks down. There's a possibility increasing the problem much more than what was reduced. Finally, when the people come to settlement and reduce into the writing part, the solution is out, which can be enforced by them. This is what the mediation means. Mediation is the best way than the negotiation, because in negotiations, most of the emotions play in the beginning. At the end, let us see, maybe 3, 4 sitting, that may be reduced. But mediation of the day, because mediator will be there in order to control the situation, control that particular part, facilitate part of it. So this is the best way part of it. Okay.
Sir, can we unmute all if they have any queries? Can we resort them for 2 minutes, few minutes?
Yes, we can do. So far,
Yeah, because
may I wait for the questions?
continuation of the subject will be interesting.
Yes.
1 second, sir. I hope everybody can unmute yourself and please ask the queries for a few minutes so that every query, if it gets resolved, we can move ahead for the other subject. Anybody have any doubts? Are you people able to 1 sec. Sir, can you unmute yourself, sir? Is it coming or not coming?
Sir, now anyone can unmute themselves.
Yeah, please. If anybody have queries, you can, sir.
Sir is in meeting.
Yeah, Chappandi.
Yes, no, you can ask the questions, please. You can have the questions now, and also you can reserve the questions to the end also. Both the way it is okay.
Yeah.
It would be
Okay,
fine.
sir.
We keep
As nobody are asking, we'll move ahead with the subject, sir. Okay, sir.
Okay.
Thank you, sir.
We'll reserve for the end.
Yes, sir.
Sure, sir.
Now, after the understanding the mediation, the importance of the mediation, Let us understand what are the different types of the mediation. One is facilitative mediation, wherein the parties here are the mediation process itself is a facilitating the parties to the dispute for that particular part. There is no question of any other thing than part. Nobody will be entering into. Mediator focuses only on facilitation, nothing more than that. He will identify one place. He will be identify the rules, how the mediation should take place. He will be sitting there, talk without any kind of interference in the discussion part of it. This is called a facilitative mediation. So the mediator is only the purpose is the facilitation part of it. And second is evaluative mediation. Here, sometimes when asked for by the parties concerned, party one or party two, if they ask, the particular mediator will be giving his opinion, the process whether they are in right direction or not. It may be in joint committee meeting or individual, separate one-to-one meeting also you can tell. This is called evaluative mediation part. And third is a transformative mediation. In this, mediator empowers parties to transform their relationship. Maybe part one, part two is a party one, party two can talk to them and change their roles. Maybe themselves agree to discuss this in openness. This is a transformative mediation. But in most of the cases, facilitative mediation, 90% will be done. Evaluative mediation will be only 10%, 15% will be done. Entire mediation will be done as a part of facilitative mediation only. Am I clear? Then coming to the what are the services where these mediation will be used. One is workplace conflicts. Wherever there is an office, there is a manufacturing or any service centers, if there is a dispute between employee and employer, or maybe customer and part of it, the conflict can be divided, resoluted with the help of this particular part. This is the best way because time will be very short. The expenses will be very less, and within one city it can be made. Again, family disputes. We'll be seeing good number of things in family disputes. You know about the many partition disputes. And what are the disputes within the brothers or between one family to other family, maybe matrimonial issues, till certain part of. Though divorce is not permitted through mediation part of it, maybe there are some disputes which can be dealt. This business partnership, another area where you can make a lot of things. Business partnership starts with a conference among the people. And after a few days, when partnerships reap some benefits, automatically disputes come there and you'll be starting fighting with them. That's the issue where we'll be part of it. Okay. Then community disputes within the community, within the society of a colony, or within a community apartments part of it, or some kind of other communities, if there is a part that can be resolved with the help of the elders of the community. Those people will be acting as a mediator, and mediator will be hearing all the parties of it. This is experience we are always seeing in our village. Personal injury claims. This is a motor vehicle accident part of it, or petty cases where the things happen, you can go for. And commercial dispute. Commercial dispute is a very big word. Your Commercial Courts Act 2015 are given a big definition of including 25 disputes as a commercial disputes under section 21C. There, what do you mean by commercial disputes? You'll be knowing that. So all these areas, this mediation can be utilized. Coming to the understanding the concept again. Number one, mediation is a totally voluntary. There is nobody who is going to direct you, who is going to force you, who is going to monitor you. It is only voluntary and it's totally private between the parties. There is no government, there is no third party, there is no other partner. This is totally party-centered negotiation process. As I already told you, mediation starts with a negotiation between the parties. These parties who are negotiating are the parties to a dispute. They'll be talking only about that particular dispute they have. They will not think about the world issues or national issues or other issues. That's what we call, say, party-centered negotiation process. It is a informal one. There is no way of addressing the mediator, my lord or sir, like that. There is no question of any words or titles that is being used. It is totally informal. You can use in first person, second person, but not the third person. So informal way with a dignity to the other party at meeting. This is an assisted negotiation process. It is a negotiation between the party, but assisted by two persons. One is your advocate sitting beside you, and other is the mediator part of it. So these two people will be helping you in your issue, how to go for that. This part of it, how the things will be going on. And this mediation, discussions, negotiations will take place only on the facts, law, underlying interest part of it. What kind of interest both the parties are having? This can be examined through negotiation. I have my interest up to this percent, he'll be having interest this particular part. And at the end of the day, the solution to whatever they're looking into is not one-way driven. It is both-way driven. Both the parties will come together and resolve issues with a win-win situation, not a win-lose or lose-win situation. It's a kind of win-win situation, which is one of the most important element of the mediation concept. And strives for effective, speedy, efficient, convenient, and less expensive process, because there's no other party involved, only two of you. You may spend some money across for sake of coffee, or maybe rent for that particular place, like that only. Other than that, problem. And whatever you are discussing, all will be recorded. At the end of the day, the resolution will be recorded, converted into a written form, which form we call a agreement. That agreement will be signed by the parties in the presence of the mediation, as mediator, as a witness, and it can be present to the court, or it will be implemented by the part of it. This is the easiest way of doing the part of it. Next. Whenever the mediation process starts, actually this is a crux. This is where the training is much more required. How to go out with that, this is much more required. And if you are not following the process, automatically the mediation will be ending in a chaos. To avoid that, there is a five stages for everything. Number one, introduction stage. In this stage, the mediator will be telling the rules, how they should behave, and what is the role of the mediator, what is the role of the giant session, what's the role of the caucus, there's the individual session, and how the resolution be drafted, and what kind of things they can be recorded, what things cannot be recorded, and what kind of language they make it. These instructions, rules made by the mediator will be informed as part of it. Second, in the presence of the mediator, both the parties will be explaining their problems. This is called a giant session. In the giant session, Mr. X will be telling his own issues and what he thought of it, what actually thing. And B, while be also there, while be also telling his own proposal or his own perception of the problem. When X and Y sit together, explain their problem, 60 to 70% of the misconceptions among the people, misunderstanding people will be resolved. Oh, I thought that. Oh, I thought this. Oh, it is not like that. You are thinking the same thing. I'm also thinking the same thing. Why the mediator told like to you like that? So all the things will be there. I'll give you an example. This example is being given by everyone who start the mediation training. There is the Akbar and Birbal issue. Every one of you knows about it. In this, one day when Akbar was in a courtroom, Birbal was with him. He's a minister. And two ladies came along with him, in fact, saying that this boy belongs to me, this boy belongs to me. Nobody was ready to help them. Even if somebody tell these two people are not agreeing. Finally, the Akbar looked into the Birbal. Then Birbal given solution to the Akbar in his ear. Then Akbar took that particular boy and called the soldier, divide into two pieces and give the two pieces to each one of them. Then those two ladies who came there, one of the lady shouted, no, don't do this, don't do this. Because she has is having the real mother love towards that boy. So she is ready to give away that boy for his life, not to kill that particular boy. Then immediately Akbar has given the boy to that lady who has stopped the killing part of it, or dividing the boy into two parts. So here the Birbal is a totally mediator. He's not told anything to anybody. Just is given some action. With this, the problem is resolved. So this kind of thing, everywhere, whenever the mediation takes place, this kind of example will be given by the trainers. So this is part of it. When the two people give the problems, second immediately is the mediator will be understanding what's the problem. The other party will be understanding the problem, actual where is the issue, where is the crux, and they'll make a note of it. Then they may discuss again openly in the joint meeting, or the mediator may have a different kinds of the meetings with individual X or individual Y, explaining them to come to know what's the real factor, real problem. This is the third stage. Maybe one-to-one meetings or joint meeting, understand the problem, making the issues to starting out the issues. That's the third stage. Fourth stage, then immediately those people in a caucus or in an individual part or in a joint meeting will be proposing from their side, this is the solution I want, and this is a solution I want. These things can be discussed. When these people come together, and after much more discussion, after discussing the small issue, at the end of the day, they may come to 1, 2, 3 alternatives. This 1, 2, 3 alternatives, again, with the help of their lawyers or something, they will be finalizing. This is the final stage. So generally, every mediation training will be having 5 different steps. So first to last. In 5 last stages, the mediator will be only silent spectator, is a facilitator. Even lawyers will be guiding their own clientele, but not the other people. They will not go and interfere in the discussion part of it. There's a informal, flexible way of the mediation process. That's why the process is called enter process in the control of the people. That's why. Next. Whenever introduction is given, as I had told you, they say it's neutral. The process will be there. There'll be ice breaking will be done, and create confidentiality and conducive environment. Joint session will be, or resolutions will be discussed part of it. This is second session. And third session, separate individually, venting out their emotions, parties to understand the realistic, brainstorm each one of them will be brainstorming. During the brainstorm, they will be able to understand what's what and what's not, whether their demand is correct or not, whether their demand is feasible or not. They'll be understanding. They'll come to some conclusions. And both of them come together, and they'll be putting the things 1, 2, 3, 4. They'll finalize, prepare a document, and exchange signed copies. And they will be, if there is already court, a case is pending in the court, this compromise or the mediation agreement will be submitted to the court final part order. And at the end of the day, the parties and mediator will be thanking to the parties. So simple, but very critical, very important part of it, without which it can be made. So far, next. So far, this particular process, what we thought, is only informally. There is no law, there is no process, but because of the importance of mediation, the Mediation Act 2023 has come into operation, and it is the directive, and it is a book or a act guiding us in order to make it. If you see the statement or the objective statement or the preamble of the the Mediation Act 2023, what it says that the act is enacted for the to promote and facilitate the mediation. Though there is other models, mediation make the best way. The government through this initiation wants to promote the mediation and to facilitate the mediation. Promotion is one way, facilitate mediation. Facilitate mediation is a very big word. For that, many actions have been taken by the government in Mediation Act 2023. Okay. Institutionalization of the mediation. So far, informal things were there. Now they wanted to put in institutionalization. Institutionalization means here, just like arbitration has been institutionalization by creating the arbitration tribunals. And there is the Arbitration Act also has come up, and ICADR has come, Delhi Arbitration Center has come, Bangalore Arbitration Center has come. Similarly, they wanted to create a place, a government or recognized place wherein the mediation can take place. So the process they have defined, and institutionalization they wanted to make it. They wanted to resolute not only disputes of commercial nature, but otherwise. Why they wanted to resolute the commercial nature means in commercial courts, in civil courts, in the high courts, crores of disputes related to the check bounce, IBC, or other company matters are lying, so that crores of rupees can be coming out from that particular group. It will be useful for the people. That's the reason for which they wanted to make it. And not only that, they wanted to legalize the process by enforcement of the mediated settlement. Whatever the settlement is there, they want to enforce like any civil order, and there will not be any kind of part in this particular. So it can be made. And they wanted to create a body for registers for mediators. There is a mediation council they are starting here. That mediator council is going to be one of the most important area where it will be directing all the things, and all the rules and regulations will be formed of that mediation council. And there is a mediation service providers will be there. They will be helping you for the mediation part. And there is a mediation institutions which will be giving you a lot of training. So mediation institutions and mediation councils and mediation service providers, there are three different kinds of institutions which are coming under this particular part. And as a specialty, community mediation they are wanted to encourage. Though earlier it was there, it was not legally recognized, but now it is a recognized. Online mediation, if people are residing at different places, in order to avoid the expenditure and time, online mediation through the help of the internet or Zoom, like that they will be settling it. And it is a cost-effective process of the mediation. These are the objective for which it is made. This mediation is available in different cases of the acts, and which will be providing you different kinds of avenues to earn. You know very well, the Civil Procedure Code, Section 829(1) talks about the audit dispute models. Now, 892D talks about the mediation. Things can be referred to the mediation. And now this Civil Procedure Code and Mediation Act has changed the terminology. Earlier, they are talked about the conciliation alone. Mediation, they are not using it. Now, according to new act and new provisions of the act, conciliation means mediation. Mediation means conciliation. Though they are now used as interchangeably. That's a part of it. And coming to the Arbitration Conciliation Act 1986, it is amended with the 6th schedule added, section 61 of the Mediation Act 2023 has changed the 6th schedule. Say that conciliation is also considered as a mediator. Initially, whatever that particular, they have not changed, and they wanted to make this particular part as a conciliation. This Act 61, 6th schedule has created a understanding that mediation and conciliation both are the same. Next, Commercial Courts Act, I already told you, there is a section 21C, which talks about the nearly 25 to 30 items as a part of the commercial dispute. And it added section 112A, replace substitute old action with the part. There should be some pre-institution mediation settlement. This is a part of it. This Mediation Act 2023, in the 9th schedule, amended 12A and substituted old 12A with the mandatory requirement of settlement of the commercial dispute with the help of the pre-institution mediation part of it. There is no compulsory that part of the dispute resoluted referred to the mediation need to be settled. It need not be settled also. When people are not able to resolve, the word term at the end of the day can write not settled is a report of that particular meeting. That report can be submitted to the court with this not settled, dispute not settled. That can be done. All these issues refer to mediation panel need not be settled at all. So this is what. Even this commercial court has authorized the legal service authority to take this process further, to train the people, to bring some of the disputes under this particular part. And this has to be settled through the pre-institutional mediation. Though before filing to the dispute into the court of law, first we have to try. If you are not able to try because of your disputes, you can go to the legal service authority. Legal service authority will facilitate the dispute settlement between the parties, and that's one of the important process. And they'll identify the mediators that can be. And this Mediation Act amendment, which is there in the 9th schedule, as mentioned, within 3 months, the mediation has to be settled. At the most, if there is a dispute between them and there's a possibility for settlement of the disputes, 2 more months may be given. That is within 5 months, 150 days, the mediation settlement has to be done according to the 9th schedule of this Mediation Act 2023. And all these things can be supervised and be monitored by the district court, high court, because legal service authorities under supervision of district court and high courts. Those with the help of the service authority, district court and high court will be making it. This is what most important things of this. So this commercial court also believed that mediation is very much important. Most of the cases later dispute settle the pre-institutional mediation, and also this Lok Adalat schemes recently conducted only these mediation settlements, maybe 3-4 times. Lakhs of cases have been settled with the help of the legal service authority recently. Maybe last year and this year, both years put together, some 12 to 13 lakhs cases have been settled, to my understanding. Then let us go to the Consumer Protection Act 2019. This act again, section 37, 37A, have been replaced or substituted with a new terms which have been incorporated with the help of the 10th schedule of this Mediation Act 2023. This act has amended the consumer protection, wherein they have created the consumer mediation councils and mediation council at district level, state level, and central level also. They required the pre-institution mediation for the consumer part also, that they have given under section 37, 37A, which is much more important for the people. If you take the Company Act 2013, old 442 section has been totally replaced with a new section, and which is there in the 8th schedule of the this Mediation Act 2023, which is with the help of that, company mediation and conciliation rules 2006 have been incorporated, recognized by the mediation. They have given how the mediation process should be there in the companies, how the conciliation process should be given. In this also, conciliation mediation are treated as only one part of it, no different part. Then IPC 2016, a committee was appointed under the chairmanship of Vishwanathan Ji. He has studied for a long and submitted a report. There is a framework for use of the mediation under the IBC 2016 and submitted this January 31st, 2024, wherein they have made there should be insolvency mediation framework, which will be going to help before for the purpose of COC meetings, for the purpose of understanding the disputes, debts, and other mostly in the official creditors part of it. So it is going to help. This Telecom Regulatory Authority of India Act by 1997 added Telecom Dispute Settlement and Appellate Tribunal Mediation Center, which is going to take up all the mediation issues, is going to facilitate the issues related to the mediation. This is the structure as of now. Now, let me talk about the Safe Mediation Institute, which is taking its shape in LB Nagar area, and it is going to help all the people. The object of the Safe Mediation Institute is provide the mediation awareness programs like this to all the people who are concerned. For people who wants to know about the mediation, conciliation, arbitration, all the things, one day or 1-2 sessions, awareness programs, maybe like this, are in detail also will be given to those people, and those people will be will be understanding the importance of the mediation, process of the mediation, how this mediation is different from the conciliation, how this from the arbitration. It also takes 45 hours training program to the trainers who are going to train the mediation personals. Those trainers will be having a 45 hours training, including Safe Mediation Institute also will be giving this kind of training to the trainers directly, also to the mediation personnel one. So once these people get the certificate from this particular institute, they'll be eligible to be a mediator, start working as a mediator to resolve. This institute may also impanel some of the members who are trained by it and call them for the dispute settlement whenever the issue comes to the part of it. And this mediation institute will be certifying mediation personnel. The certification says that Mr. So-and-so has undergone certificate conducted by the Safe Mediation Institute for 45 hours, and he is eligible to work as a mediator, and he can be paneled by any person or any institution for this particular person. This kind of certification will also be given. Now, Mediation Institute is working with Singapore and other international bodies in order to get accreditation internationally so that these people may go and act other countries also. And in addition to this safe mediation will also facilitate a platform for the dispute settlement, undertake the mediation process on its own if they are annexed to the court or if they are annexed to any other tribunal. If the tribunal requests or the people request, they can call the two parties and help the party create the platform, facilitate them in order to for this particular part. And it also helps the authorities of any companies or in kind of insolvencies. Example, IPs will be having their disputes with some of the members of the COC or creditors, or maybe about the waterfall mechanism, there may be some dispute. Some specialties may be there. Some kind of this cyber frauds will be there. All those things, wherever there is possibility, the Safe Mediation Institute is going to help the authorities in resolving them. So it is having five-pronged objectives now. One is it conducts awareness program, brings the importance of mediation into the system and encourage the growth of the mediation. Second, it trains the trainers in order to prepare them to mediate the other people, and directly trains the mediators. Certification part it will take, and also it will the issues. These are the different pieces part of this. This is a small presentation in nutshell, not in detail. Just we have given. I have not discussed anything about the act because it needs a lot of time for the settlement part. Now you can have the questions. Yagna ji, T.S. Raja ji.
Sir.
సో ఈ ట్రైనింగ్ ప్రోగ్రామ్ అన్నారు కదా సార్, దానికి ఏజ్ క్రైటీరియా అంటే స్టాండింగ్ ఇంత ఉండాలి, లేదు ఎలా అప్లై చేయాలి? అదర్వైజ్
you can have the training program online or physical mode, which will become communicating to all of you very shortly. There is no age requirement, but minimum age will be more than 18 years because minor cannot be a mediator. And advocates can be there. Some of the CAs, ICAs, company secretaries may be a part of that. And though they are eligible for that, the training will be sharpen their mind. They'll be instilling the process into their mind so that they will not be going deviate. Sometimes our personal characteristic traits will come and overrule the rules of the game. That should be controlled. That's why we'll be coming there and we'll be telling them what is not to do, what not to do.
Okay.
Total how many?
Yes, sir.
In total, how many days the training program?
It will be 5 days, every day 8 to 9 hours. It includes the theory and practice also.
Okay. So some sample cases will be given at that point of time to.
Yes, every day, half a day in the evening, will make you to do some kind of mediation.
Okay, sir. Thank you.
Some problems given to you, you'll be part of that, and we'll be supervising There will be rooms. Whenever you are going wrong, we'll make a note at the end of the day. This is way you have to do it, but you do it like this. You'll make corrections part of correction.
So when this particular notification will come regarding this?
Very shortly, maybe within a month.
Okay, thank you, sir.
You are
Please
welcome.
let us know, sir. Many of us are interested to participate in the same, so that we can participate on all your activities.
Yes, certainly. Our intention is to bring the objectives of the Mediation Act further into the roots of the society. So when we start, automatically we'll be informing you through mails and also WhatsApp groups, all those things. And every group will be having around 20, not more than 20, 25. So that we may concentrate upon the people individually. If we take good number of people, again, that will be a very big problem. So we'll take 20 people maximum, the most 25 people, and we'll see that everybody will be undertaking practical aspect of the case by themselves. Certainly, we will update through WhatsApp group and also this part. This program may be offline one time, online one time. Though both things can be done. Online and offline, minimum 45 hours should be there. It may be Saturday, Sunday also, sometimes depending upon that. If required, 5 days, 6 days, 5 to 6 days. 5 days are enough as per the rules, but we want to extend half a day more so that you'll be getting more clarifications if you have any doubts.
Sir, only for Hyderabad or some other places, sir?
Some other, if you want to come physically, we'll provide you physical facilities at our place. For your stay, we'll be providing to accommodation also at your cost. Accommodation also will provide at your cost.
Structure for this course, sir?
Yeah.
There is any fee and all?
Yes, fees will be there, which is fixed by the government, and also we are negotiating with them. We are examining all other institutes also.
Yes, sir.
Yeah, online people, you can join online people, but things that online people should be very cautious. Online problem with online is they'll switch on the things and they will do other works side by side. That should not be there. When you are joining the online program, 100% you should be with the program. If you are missing 5 to 10 minutes, some of the technical issue you may lose. So that is going to hamper entire your learning part of it, which we don't want. So there is a possibility of online. Online can be done only with the help of this particular part.
Sir, is it affiliated to any universities?
It is not affiliated. The institute itself is authorized to do it. We are talking to the people in Singapore and other places to having a what's called affiliation, so that they say affiliated by Singapore Mediation Center like that, or American Mediation Center, Japan Mediation Center. That work is going on. Because of that only we are making a little delay. When that comes, it will be coming. You will be totally authorized.
Okay, thank you.
Yeah, Sridevi, with your permission, I take a minute. Okay.
Yes, sir, please. This is TSN Raja. He is now insolvency professional. He is my guide, mentor, and today, in fact, in my ideas, he cooperate. He gives some moral strength to me in all the time. You please go ahead, sir.
Now, basically, this awareness program is called to let all of you know that apart from being an advocate pursuing in, say, magistrate court, district court, high court, etc., this is one area which is going to be an explosive opportunity for all the professionals, both young professionals and also those who have completed 10 years plus. And the other thing, what I wanted to make it easy for everybody is that, as Narasimha Garu explained, the mediation is going to be of two types: court-attached mediation, party-preferred mediation. See, there is a dispute, either of the party prefers a mediation, he may go to a mediation center and request the mediation center to take up this issue and get allotted to a mediator attached to them and resolve. This is one type of mediation. The other is, there is already a dispute. Once the act comes, the judges will be preferring to advise a mediation. They may hold the process for some time, constitute a mediation team, and then try to get a resolution. So that way, those who are senior practicing in Supreme Court, High Court, etc., they will have opportunities from the High Court or Supreme Court where they are practicing, and others may get it from district court or any court, or parties themselves may go to a mediation center. So that way there is going to be a phenomenal opportunity for all the professionals, both new and experienced in this arena. And as Narasimha Garu explained, I don't know how many of you heard it or not, he was mentioning about ease of doing business. For your information, for the information of everybody, today, any enactment coming in India may not be the brainchild of Indian government or initiated because of by a Supreme Court or something like that. They are all imposed on us. Unicitral is there. Unicitral comes with model laws. For your information, IBC came like that. GST, a single point tax, came like that. Commercial Disputes Act came like that. So everything nowadays is coming because the foreign, see, the government, all the developing countries look for foreign direct investment. When foreign direct investment comes, the investors also seek an exit route, a quick way to exit also, with or without profit. If there is some emergency in America, they want to take back the investment, there has to be an exit route. So these enactments are facilitating exit route. And I'm telling you, if IBC and GST has reduced the rank from 140 to 55, automatically this implementation of mediation is going to bring down the rank, I mean, increase the status by at least 10 points. So that way we may in future see the ease of doing business of India going up to a number of 45 in near future. The enactment, the notifications are yet to come. Some procedural guidelines are yet to come. But with the experience, what I can say is those who are professionally qualified with some reasonable experience will get an opportunity in some or other way to involve themselves, practice themselves as mediators. So with that background, yeah, thank you, Narasimha Garu, for giving a platform, and thanks for Yagna Legal and Sridevi for giving us an opportunity on either thing. So we are in near future, maybe within a few weeks, we are going to announce our first training program, and regarding the fee and everything, maybe we will, before we launch, we take once again this platform to reach to you, saying that yes, this is what we are proposing. And for your information, in India, the fee that is charged for 45 hours ranges from 35,000, and in other countries it goes as high as 1.5 lakhs. But we may be trying to, as Narasimha Garu has highlighted the importance of a hybrid model or a virtual model. See, if there is a physical model, then what happens is IICA charges something like 45,000. They make the faculty to fly, that costs the institute in arranging. So if it is virtual, there will be savings. That savings can be passed on, or additional trainings can be arranged, keeping that within the same thing. We will be reaching to all of you in near future. Okay. Yeah. Now you may have ask your questions. Narasimha Garu and Sridevi will answer. Yes, sir.
Here I have a layman question. When I invest that 45 or 35,000 on this course, what would be the career opportunities that I am going to get? And in fact, with us, with Yagna Legal, nearly 5,000 junior advocates are connected with us. Are you going to give any discount or additional advantage for us? Likewise, we have some questions.
Yeah. No,
Sridevi Garu, we'll be only now calculating and working for the betterment of the people only. Once we come to some conclusion, we'll come back to you. We'll try to discuss to you, disclose to you. Okay? Is only
and regarding that investment part, I tell you one thing. If you plant a red gram, the yield will come in 6 months. If you plant a coconut, the yield will come after 5 years. So, so what I say is, it is an investment.
It
And why not only me, not only us, several people are trying to establish mediation centers. Several people are trying to establish mediation institutes. Why? Because we see a lot of opportunity. When there is opportunity for the professionals, see, all of you, when you say 5,000 are there, I hope at least I will be in a position to get 50 of you as members attached to my mediation center. So it is win-win for all. If you earn as a practitioner, we earn as facilitator. It is win-win for everybody. Okay. Yes, sir.
And Sridevi Garu, let me add. Suppose in Indian cricket international match, if you allow you, if you take you, what's the benefit for you? Depends upon you. How better you bat
yes,
or field. With that, you'll be getting some more benefits, maybe remuneration, advertisement, so on. Here also, we'll try to give a good training to you. The way how you bat in the market or how you bat in the mediation world, that helps you. Maybe 6
yes,
months, maybe 1 year, maybe 2 years. It's a kind of a part.
yes, sir. Actually, it is like insolvency issues and some
Yes.
company issues. It's a big person scheme. A
No.
fresher who just joined in the institution is getting very lesser opportunities. Hope this way give an additional opportunity for the freshers.
Exactly. Big man's game is in the court, not in the mediation. Whether it's a big man or a small man, the duty is only one. He should facilitate, that's all. Nothing more than that.
Yes, sir.
And he cannot come as a active role. He's only a facilitator, nothing more than that.
Yes, sir.
So
Sir,
everyone is
Narasimha Rao,
equal. Where everyone is equal. Yes, sir.
good morning, sir. This is Jaykar. Good morning, Sridevi Madam and Raja Garu. It's a privilege that you top big shots have come, volunteered to educate us, enlighten us. I have a quick suggestion, sir. Quick suggestion.
Sure.
I am also into cybercrime handling, and most of them are coming for compromise, sir, because of the
Yes.
huge penalties.
Yes.
So recently, I completed a small workshop for educating our advocate fraternity for 10 days.
Yeah.
So, as a feedback, also, I got information that not much of cases are there for adjudication.
Yes.
When they realize that the penalties are huge, they are compromising and coming for
Yes.
compromising. So
Yes.
I adjudicate, I mediate and enable the adjudication process to bring down the cycle time of adjudication process, sir.
That's a great.
I'm handling currently that compromise only, because the penalty is huge loss and the victim is after me, but the accused is more after me to settle the matter as early as possible.
Yes.
My profile I need not say, but I'm 30 years in the industry, sir. I'm a cyber law graduate with LLB. So I can be of great resource in your upcoming mediation center or institution, so that I can tell how these people are coming for mediation or compromise.
Sure, sir. Sure, sir.
Live cases I can talk without naming them or citing their case numbers or FIR numbers.
Yes.
Sure, sir. Certainly.
Yes, sir. Thank you, sir.
Jaykar Garu, I have a suggestion for you.
Yes, sir. Please go ahead.
Yeah, Jaykar Garu, are you able to hear me? Yeah, I have a small suggestion.
Yes, sir. Yes, sir.
Why not create a outfit which will identify those sites which are initiating cyber frauds, and that way minimize the loss caused to the public. See, now it's a deviation, Sridevi, with your permission. See, whether it is an assistant commissioner on an ordinary college student, if they are trapped and attracted by, lured by the profit offered and they make the payment, there is no chance of getting back.
Yes,
there is no chance. And maybe even tracing them or trying to find, ultimately, if you trace also, you will find a person who is a rag picker like thing drawing 11 lakhs from the extractor money. Okay. So my
Yes, sir.
suggestion is, why don't you, with your experience, create an outfit? I'm ready to support. Create an outfit
So
whereby
kind of, sir.
you will take a couple of fresh engineering graduates and then create a mechanism like hawking is tracked. So like that, like a hawker, they go and find out what are all these sites that are giving these false notifications and things like that. Maybe we will work out. We use Sridevi also rope in this Narasimha. We try to do something. We will be real use to the society. Okay. Right, sir.
Thank you, Rajagar, for your nice suggestion. Definitely, sir. As a awareness creation center or as a awareness creation forum, I suggested in my recent workshop, Agna Legal Madam Sridevi to camp, like conduct camps for awareness. So we can pick up the audience. Like in 2017, sir, about 600 people heard me about the cyberbullying, cyber stalking, and created awareness to the cyber crimes. Because most of the girls, moreover, leave alone girls, all the women folks sitting at home, they want to tell, today I have worn this silk sari, and they will project a picture. And then these girls, today I brought a nice jeans with holes. They want to project that as a lifestyle upgradation. But actually, they are giving themselves to the devil's prey, are becoming a devil's prey. So I've educated about 600 students, which was well taken. But later, like I frequently go abroad and come back, sir. I was a SAP consultant, worked for 20 years plus in BHL. So I used to travel, and after COVID, I stopped traveling abroad. So that gave a small stop, not stop, but deferment for my awareness initiative, sir. Now that we know Raja Garu and Narasimha Rao Garu and Madam Sridevi, so we can really start kick off such a kind of initiative, number one. And sir, as Raja Garu, you have pointed out, we have, like there are many AI tools, sir. I'm MTech in AI also. So there are very easy tools to, like OpenAI is from the open source. Likewise, we have free AI tools in crawling or scraping, which I have just told in my workshop also. So these scraping tools can be identifying those false notifiers which entrap the gullible people, sir. So I have ready-made tools and ready-made algorithms to run and work out as a chatbot or any bot which nibbles around the websites and then comes up with the fooling sources, sir. Sources could be institutions, as you rightly pointed out. So with this, I don't want to steal the time. We have a lot thing to talk about, and we can have a separate session amongst ourselves, seniors, so that we can come up in association with Yagna Legal Madam. Sorry, Sridevi Garu.
We will work out on that issue, sir.
Yes, Sridevi, you have a topic for someone next session, future session. There is a topic for future session, and let me take one more minute. It may be a common thing for Jayakar. Let me tell you one thing. A small incident that took place recently with one of my associate. One of my associate, what he has done is he parked his savings in his father's account. The simple reason being, he gets as a senior citizen extra 0.5% interest. He literally, my associate, parked 28 lakhs in his father's account, which is not having a debit card, no internet, nothing, there is anything. And every time he deposits, he gets a hard copy of the FD, fixed deposit receipt. And one guy who was associated with the bank earlier as a contract basis, that guy identified this account. And then what they did is, they gave a letter to the concerned branch saying that they are requesting for a debit card, and then they asked the debit card to be mailed to that. In the same letter, they requested the contact number and mail ID also to be incorporated. So the bank branch took it in a genuine way, thinking that it is from they must have compared the address. It is the same beneficiary's address. So what they did is they initiated the process. The first thing what they did is they incorporated the phone number, they incorporated the mail ID, then they got the debit card processed and sent it. Even before the debit card reached to the beneficiary's address, what they have done is they have converted the FDs into they cancelled the FDs without submitting the hard copy, and they withdrew 28 lakhs from the account online. It was distributed into 7 states, 16 accounts. Within 2 days, all the money is drawn. And when the debit card came to my colleague's father, he said, "Beta, ye kuch aaya mujhe." Then this guy shocked. How did it came? So when he went there, he called me in the night around 9:30. He said, "This is the bank." I said, "Look, I will give you the regional officer of that area. Try and go to and explain this problem." This was done. A police complaint lodged, everything done. It is literally 1 year. Not a single rupee is recovered. So the things are happening. So you may be thinking that I have an FD, I have it in my hard tijori or a locker. It is of no use unless you are keeping a guard of your account and things like that. Anyway, nice. Thank you. You carry on, madam.
Exactly, sir. Raja Garu, it's a nice anecdote. One of the 7 states is Jharkhand, and one of the city is Jamtara. So these are prominent things which I told. There is a RBI circular where the banker becomes, or the onus lies on the banker who transferred this 28 lakhs into 7 different states, because the source is only one, the poor old man, your colleague's account. So payer pay is the concept. So easily we could have meaning frozen before the final transfer, because there is a window of time where the account is blocked to enable the transfer. To enable the transfer, there are some credentials to be ascertained. That is 2-factor authentication, 3-factor authentication, without which no money can be transferred. So the banker is the responsible. Banker is also party to it. That's why, like in our current case of Dr. Mamata's case in Kolkata, all are involved in this. So you can still try, and based upon the RBI circular, you can sue that bank which transferred into 7 different states or 7 different accounts. Thank you, sir.
Thank you. In fact, we are diverting things. So thank you so much, sir, Narasimha Rao sir and Raja sir, for giving this opportunity. In fact, we want to know better things like this. I have been asking Raja sir to teach us on insolvency law aspects, but because of his busy schedule, he's unable to take us that session. Hope very soon he will take. He is asking for the panel discussion on different topics. He is suggesting like that, and with your all blessings, we do the same. So thank you so much, sir.
If anybody is having any questions, last minute, anybody having any question, you can shoot to them. Any doubts, any questions, anybody? Have you enabled unmuting by them, Sridevi?
Yes, sir. They are all. Madam Anita, you can ask any doubt you are having. This lady is from Vizag, practicing advocate. From Vizag, she is having more than 20 years of standing. But nicely, she listened to each class. She contributes her ideas with us.
Then she can be a good mediator, because she has to hear the parties
Yes,
calmly
yes.
without
She
any.
do sometime in family disputes. Most of the time, she tried to do the same.
Yes.
And here we are having problem, like we are doing mediation with regard to only family disputes most of the time.
Yes.
And
Yes,
with
ma'am.
regard to other aspects, we are not getting the opportunities. As I said, it's a
Yes.
big person's game. So hope with your help, we to get that opportunity of
Yes.
dealing bigger things.
Yes.
Maybe I think ladies are best suited for mediation. They are used to listen to the rubbish of his husband. Whatever her husband says, whether known subject, unknown subject, interested, not interested, keenly without showing their displeasure, they listen. So
Today
they
we
are
are
the best mediators, I guess.
Today we are at home. All of they are listening to your words.
Yes. Especially this mediation part is what you say is absolutely right. Big person's job, ma'am. This is most of the even judges also are involving in this mediation conciliation process. No?
Generally,
So we are not getting.
general judges in mediation also act as adjudicators.
Yes, sir. Yes, sir.
That is not acceptable. I
Yeah.
used to
But
tell
they
the
are
judges,
actually-
High Court judges.
Yes, High
Maybe.
Court judges are Praveen Kumar.
Yeah, High Court advocate judges. I told him, sir, you are the mediator, not the adjudicator, the arbitrator. You should not talk. Simply sit. That's all.
But we by doing journey with you, we may get the different opportunities, I believe, and I will be definitely a part of it.
I'm sure, ma'am. I may be.
Anyone is not able to join physically, you have other option of going through online. Make use of it, and whatever the updates I get, I will share with you all. And soon after a notification, hope again that Narasimha Rao sir will join with us and explain the course curriculum and all, so that we get some motivation and importance of that course and all. Hope
that we can pursue our profession through this course also in a
Yes,
better
you can-
way under your guidance, sir.
Yeah, sure.
There is no restriction.
Yes, yes.
Others
In addition to what we are doing, we can do more mediation also.
yes,
But there should not be any conflict of interest.
yes, sir. Yes.
Okay, Sridevi Garu.
Yes, sir.
Okay,
Yes,
thank you,
sir.
Raja Garu.
Thank you, sir.
Thank you,
sir.
ma'am. Thank you
so
for
much.
facilitating. Thank you.
Thank you, sir.
Thank you so much.
Have a nice day.
Definitely we will be helpful and advantageous